Hello, Allison here with my paralegal Jessica, and we want to share with you some information about the fiancé visa process as compared to just the spousal visa process if you are either engaged to a foreign national or considering engaged or getting married, and what might make the most sense based on your situation.
As it pertains to the fiancé visa, some of the basic requirements are, of course, to have the intention to marry within 90 days of your immigrant fiancé entering the United States. You must have also been physically present in each other's presence in the last 2 years. And you must have evidence to substantiate that there is a relationship. We can be creative with what evidence looks like, but, for example, calls, text messages, pictures, flight itineraries. And then for a spousal case, of course, you need to have evidence that you have been married outside of the United States.
Perfect. So both of the processes are done through the consulate in your foreign national fiancé or spouse's home country. Just wanted to point out a couple differences between the two visa types because I get that question a lot. Now, first and foremost, if you don't have the means or the way by which to travel to that your significant other's country and legally marry them, then the fiancé visa is going to be the better option. Aside from that, I typically prefer to file these cases as marriage-based cases simply because of the benefits that the foreign national will receive when they enter the United States. So in both scenarios, you need to file a petition that establishes the relationship like Jessica was describing. So evidence that shows how you maintain your long distance relationship, how you communicate regularly, maybe there's financial support, maybe there's vacations you've taken together. Both of those are filed stateside with USCIS. Once those are approved, the cases get forwarded to the U.S. consulate in the home country where your significant other will apply for what's called either the fiancé visa or the immigrant visa if you're already married. That's where the difference of these cases come into play. In either event, once they get the visa approved, it is for a one-time entry over a 6-month period into the United States. If they enter on the fiancé visa, you have 90 days to get married, and then once you're legally married, you file what's called the adjustment of status or residency application for them. So there's basically a 3-step process with the fiancé visa: petition, consular processing, adjustment of status. Now, on the marriage-based visa, and the reason I prefer this a little bit, depending on your situation, is because once they get through that consular processing part and they have the immigrant visa, the case is pretty much done. They immigrate to the United States, and the moment they get through the airport, they are considered green card holders or permanent residents because you've already been married. So there's no more red tape, there's no more process, there's no rush to hurry up and plan a wedding within 90 days, which is a really short window, not knowing when that visa will get approved. The other benefit is as soon as that person gets through the airport and is here, they have work authorization, they get their social security number, they're basically set up and ready to start their life. Whereas the fiancé visa, there's a lag in the paperwork and processing times to be able to get up and running. Now again, like I said, the fiancé visa does work better in some contexts, so this is just speaking very, very generally. Of course, always give us a call and consult us. If you have any questions about your case specifically, we'd be happy to help you find the right fit for what legal process makes the most sense. Thank you.